Hi everyone, it's your friend Doris the Coder back with another video. Today's video, avoiding compliance pitfalls. I'm going to give you 3 tests you can follow to avoid ending up like these case examples that we're going to use today. Now, disclaimer here, this is public record. This is not, this is the OIG's website. This came from their notification today. I'm going to give you 3 tests you can apply to hopefully help you avoid some of these compliance pitfalls. We'll review these cases and I'll give you some historical examples to tie it all together. So test number 1 is the value versus work test, right? Our value and work test, right? So these are going to be combined. Just to give you a little history here, providers, when you are paid under the physician fee schedule. Now, an exception to this is one of my specialties that I deal with is anesthesiology. They don't follow this methodology. It's a little different when you deal with the formula for anesthesia payment, but the Medicare physician fee schedule, for example, and all the fees are kind of based off this one way or another, is based on this bottom formula part that you see here. So this is, I'm in Florida. I actually use Florida. Medicare First Coast Service Options is the MAC. In anesthesia, that's monitored anesthesia care, but here I'm referring to the Medicare administrative contractor. That's the entity responsible for administering the Medicare program in my state of Florida. Some MACs actually have multiple states as well. So here, this is the area we're going to focus on down here. So when a provider gets an allowable amount, a flat, kind of fixed fee, a maximum amount they're able to collect for that service, that is not just blind or random. There are some geographical considerations as well, but it's based off a formula that's mentioned here. So one of the first things they look at is the work, right? The work associated with how much the provider has to use in order to accomplish that procedure, right? So just think, work, right? What kind of work they have to deal with. It is the one factor that is consistent, irrespective. Like the work is always going to be the same. How much of your expertise you have to apply, what kind of clinical skill you have, all of that applies to that particular factor. So the work RVU, relative value unit for clarity, is part of it. The other 2 factors that make up the allowable are what they call the practice expense, right? These fluctuate. So the reason you have one FAC is facility, non-FAC is non-facility, is if a private provider, for example, like, some of my paying clients, they perform procedures in their office. Whatever your specialty is, there's some procedures you can perform in your office, and those procedures might also be performed in a facility. You'll find that not every code has a facility and non-facility practice expense because some procedures cannot reasonably be done in a non-facility setting. So the practice expense has to deal with all of the incidentals that are needed to accomplish that procedure, right? So if I'm doing a nerve injection, I need a needle, right? And I don't bill separately for the needle and supplies and all those kind of things, which is why you see it fluctuates between facility and non-facility, because there's some expenses the provider kind of just has from a practice expense perspective. But most of them, when they're done in facility, the majority of that is kind of taken over by the facility. So you'll see, that's why you see different fees and different allowable amounts based on where you do some of your services. And then the last piece is the malpractice expense, right? So work, practice expense, and malpractice expense, right? The malpractice has to do with the technical complexities and risk associated with that procedure when it comes to that provider performing it, right? So, a needle in the back might have different risk than a needle in a toe joint, right? Just for clarity and a comparison, right? So the first test of applying the value and work test will help you. I found it interesting that this device, I remember this device from several years ago, like years and years ago. I was getting emails from coders, and I had a provider that's like, yeah, I think I want to start doing this procedure, and it's really simple, and it pays so much money, and we'll get into that in a second. It's really simple, it pays so much money, and you just have to do this, and this is what is being paid for it. I advised my client at the time that just sounded too good to be true, It didn't make sense. I applied the value and work test by looking at the code they were recommending. Now, and you don't always have, that's an important point. You don't always have kind of published guidance. So these tests are important and helpful when you don't kind of have published guidance. But I'm thinking, okay, my knowledge of this, let me see. You're saying technically, I said, talk me through this procedure. How do you do it? What is it? What's the purpose? And it was this auricular device that they kind of stuck on the ear, auricular's ear. So they kind of stuck on the ear and it was doing this little stimulation or something and it was helping with some kind of pain. The efficacy, I'm not sure about, but that was the device. The code that was recommended was an implantation code. That immediately, I guess, didn't pass my sniff test because I'm thinking it's not implanted. You're saying there's surface electrodes. So this code doesn't feel right. Um, we had entities providing us with EOBs saying, hey, look how great it pays. My provider dropped this off on my desk and look how great this pays. And I want to start doing this procedure and it pays so well. And I said, okay, well, with the value and work test, I said, would you agree that it's more risk for you, or is it more technically complicated to do this procedure or put a needle in a patient's back? The provider agreed, like the needle in the back is definitely more like complex, requires more skill and work and all of that. And I said, so that code, one, I immediately knew that wasn't the code, but I said that code that they're recommending not only doesn't reflect that work, but if you're explaining the value to me and the risk associated with it too, why would I be paid so significantly less, so much less for a needle in the back than sticking something on the ear? So it did not pass the value test and the value and work test, right? First test, right? The second test you want to consider, and let me back up for a second. Providers, bear in mind, coders, billers, reimbursement practice managers, whatever. These are folks that should have the time and make the time to ensure things are done compliantly because right? Compliance is not a singular task. It's not a single department's role. It's not a single person's role. Everyone in the organization should have a commitment to compliance and have a hand in it. So if you have someone that says, I don't think we should do this, that doesn't make sense. That doesn't pass kind of the common sense. I think we have risk or we shouldn't. A person who works for or on behalf of your organization, a billing company, your practice manager, your biller, your coder. These are folks that work for you, either directly or indirectly. They are more likely to have your best interest in mind than the seller of, in this case, the device. Not that I'm saying they would intentionally do anything underhanded. I'm not disparaging a profession. I've known some really good device and drug reps and everything like that. But their interest and their primary purpose is to protect their employer, which is the device seller. So you retain all the risk. You can't say, well, this is what they told me. In fact, I can even say there are times where those organizations are very good sources of proper guidance, but not always. And you've got to take personal responsibility because if your name goes on the claim, it is your responsibility. And they told me to do it, or that's what they said, is not enough to excuse you, right? You're not going to get a pass because, oh, well, you were misinformed. You can go ahead and keep it and we'll turn the other cheek. That is important because when I look at this case, we're going to come back to this one. This is another provider for the similar device. That was an anesthesiologist. This is a chiropractor who did it. Same kind of issue. The value test didn't make sense. And remember, the people who work for you or on your behalf, they're advocates for you. So they certainly should be. I definitely want to believe these are advocates for you. They are not adversaries. So how you approach that relationship and how you address what they bring as a compliance concern can really make all the difference in the world for what that means for you. It's not uncommon that there are often whistleblowers in these kinds of cases because someone said, hey, I don't agree. I don't think this is right. And they were disregarded. In fact, in this particular case, the one with the chiropractor, Dr. On was the name of this provider. They cited, and I think this is very intentional on the part of the government, they intentionally published this to let you know this is how we work. We want you to be serious about compliance because we are. It indicated she and her staff ignored warnings and specific guidance from Medicare contractors and her own outside billing companies, including warnings that they were being labeled, that the devices were being labeled as possible fraud. Right? If I'm a billing company and I take a percentage or a flat rate, whatever the methodology is, I have a vested interest in you making money. So if I say that's not the money you want, or I don't think that's right, or I'm an employee who works for you, right? I have a vested interest in you keeping your doors open because your doors open pays my bills. Why would I want to keep money from you? Like that just doesn't pass the common sense test. But in this regard, in this case, it appears that this provider disregarded the staff that was trying to protect her by saying they were, protect her by saying that she wasn't correct in her billing of it. So the second test is the medical necessity test. All right. So why are you doing this now? What value does it add? Are there studies to support what you're doing, for example? Why now? Providers should realize that you can have risk even if you didn't build a claim and you think, well, that doesn't make sense. You submitted or caused to be submitted a claim can be quite legally objective. Again, see an attorney for that. But the reason I support that is there's a certain kind of provider that I've reported for that always needs another provider. If you bill for diagnostic tests, for example, labs, radiology, they have in the Medicare rules, they define a treating physician. Well, a radiologist is not a treating physician. An interventional radiologist is a treating physician, but a typical radiologist that would read an MRI or a CT, they are not a treating physician because they do not have the benefit of a face-to-face examination with the patient. So any test they perform is based off someone's, from a necessity standpoint, is based off someone's face-to-face with that patient, all right, or someone who had the benefit of examining that patient. So if you are generating, and this is how they find a lot of the improper relationships, if you are generating orders that cause claims to be presented to the government for payment as an ordering provider, you have risk. Okay. Which we're going to see with one of these lab things, right? So, does it pass the medical necessity test? The second case I find is important, and providers think about this from a risk perspective, which is the third test, the risk test. The 5 words I often, or 4 or 5 words, depending on how they say it, I often hear that make my heart stop a little bit every time I hear it. It just makes me kind of pause and take a breath. But we're getting paid. We're getting paid, and that's not an untrue statement. We're not seeing denials, but we're getting paid. So when someone gives you advice that what you've done is incorrect, there is a belief that if I got paid, I did it right. And to that, I counter and say, are there times you did it right and didn't get paid? So payment is not assertion or like the test of righteousness, right? That you did it correctly. Because we get denied all the time for things that we should have gotten paid for. So you might be getting paid for things that you should have gotten denied for. So this is one of the cases that kind of enforces that point. Just as the government audits providers, the government also audits entities that are responsible for administering certain tasks. For example, MAC is monitored anesthesia care and anesthesia, but it's also Medicare administrative contractor from a reimbursement perspective. Medicare administrative contractors are responsible for administering the Medicare program in their respective jurisdiction or state or states. Some of them have multiple states. They are responsible for policing and kind of controlling the money that goes into Medicare. So in 2019 alone, and this is just one calendar year, Medicare paid $180 million for drug testing services. And when they start to get that kind of money, and this is test number 3, when they pay out that kind of money, they want to assess control. So when I say test number 3 is the risk test, if you're wrong about how you bill or report a service, ask yourself how much is it? And you think high dollar, that's going to be an issue for you, and high frequency. Drug tests, especially point of care cups, they're not high dollar. But if you have a pattern for doing them with everyone, they could be high frequency. And that becomes particularly risk for you if they find out it's fraudulent, because when it comes to some of these penalties, if they hit, it is per claim. Now, claim, that's kind of a legal definition that I feel is not fixed. But a claim, I think as a biller, oh, if I printed out a HIPAA form, there's 6 lines on it. Is that a claim? Where I've seen in some of the data that per claim is per claim line. So if you have a pattern where you order all the, a drug test for every single patient, you could have a challenge because you're doing that for every single patient and you're creating many claims for each one of those patients. That can be a problem for you. But to go back to the point of, but we got paid, but we're getting paid, or we're not seeing denials. This is in this report that came out today, the OIG actually is kind of looking to the Medicare administrative contractors to say, hey guys, you understand what your role is here. How are you, do you have controls in place to make sure we are paying for services that are medically necessary? Convenience is not medically necessary. Screening, there's a lot of things that don't meet the medically necessity definition by the government. So you want to make sure you're meeting that medical necessity definition. And if you're doing it always for all people, irrespective or whatever, you might not be doing it for reasons of medical necessity. So the MACs here kind of got their hand kind of slapped a little bit to find out what controls are in place in order to identify this misuse. You can read this article on the site. I'm concerned. They make a few recommendations. And of the 5, the last 2 they concurred with. So I wonder if we're going to end up seeing a new modifier come out to identify the definitive test that's the result of a presumptive test, right? That we did a presumptive first and we needed additional, so we did a definitive test, which makes a lot of sense for those of us that are reporting those lab services. But again, what are the lessons here? The lessons here are providers. If you've got people who are bringing up what could be compliance concerns, billers, whatever the role may be, understand these are advocates for you. Like these aren't folks that get paid off a percentage. I would even say the billing companies, like even if you get paid off a percentage and they say there's an issue, they really need to be listened to because it would be beneficial for them for you to make more money, right? Because they could take that percentage. So remember, they're advocates, they're not adversaries. Apply the three-point test that I give you. Point number 1, value and work. Point number 2, medical necessity. Point number 3, risk. Can you afford to be wrong? What is the risk if you are wrong, right? Doesn't mean that if you say, oh, it's a lower risk or we don't do a lot of them, we don't care, that you won't get a penalty. It's just maybe the penalty won't be as high. Maybe you want to take the risk. But remember, entities are representing their best interests. And maybe it's a lack of diligence, maybe it's intentional misinformation. I don't know. I don't want to opine on that in that regard. But as a provider, you have unique and sole responsibility for the claims that are generated on your behalf. That's why there is a signature or electronic signature replacement that goes on every single claim. You are asserting that that is proper, and it goes under your name, so you want to make sure it is. So I'm your friend Doris, a coder here on YouTube. I hope my 3-point test can help you avoid compliance pitfalls. And you know what I say, like it if you do, share it if you know someone that'll find the information helpful. Give me a comment, let me know how I've done. And if there's any feedback you want to share with me, feel free to share with that. Until then, I will see you in the next video. And this is Doris, the coder, signing out.